What is the Florida probate process? Hey guys, welcome back to our channel. Today we're going to give you a quick overview of the probate process in the state of Florida. So let's go ahead and dive right into it. Under Florida law, there are three main types of probate. First is formal administration. Second, summary administration, and finally, disposition without administration. So let's go ahead and take a closer look at each one of these. The first type is called formal administration, also known as formal probate. This process is the most common and occurs in the local circuit court of the county where the deceased person resided. It begins when the executor of the will or another interested party does request to be appointed as the personal representative of the decedent's estate. Once that request has been made, the beneficiaries named in the estate receive notice and do have an opportunity to raise any objections that they may have. So quickly, if you guys are new here, my name is Melanie, and I'm better known as the probate nurse in the greater Tampa area. I'm a nurse, a senior transition specialist, I'm also a realtor and a probate advisor, and I love to create informative videos about senior transition situations that could range from probate to estate planning to simply assisting families with all of their needs and sales. Please click the like button and hit the notification bell to get notified every single time I release a new video. This does help to get this vital information into the hands of people who may actually be searching for this type of info right now. The second type of probate is summary administration. This form of probate is available when the property or assets going through probate court are valued at $75,000 or less. It can also be used in cases involving a death that occurred over 2 years ago, such as when a missing person is officially declared deceased. To initiate this process, a petition for summary administration must be filed, which usually requires the signature of a surviving spouse and or beneficiaries. Summary administration is a faster and more expedited version of probate. Finally, we have disposition without administration. This process allows for skipping the probate hearing entirely under specific circumstances. It's important to note that this option is only available when the deceased individual didn't leave any real estate and the value of the assets available for probate is lower than the final expenses. In this case, instead of going through a formal court hearing, a form called disposition of personal property without administration needs to be filed to recover those assets. And that's it for our quick overview of the probate process in Florida. Remember, whether you're dealing with formal administration, summary administration, or disposition without administration, it's always important to consult with an attorney who specializes in probate law. And so now you know. Thank you guys so much for tuning in and for watching, and we'll see you on the next video.